when exactly did this unlawful plan, come to fruition, and when was it exactly agreed upon? 3 weeks, from in my eyes, and I think as well from the defense perspective, is not a clear delineation of when that agreement took place.
Robert Krajcik reporting here in Ottawa, Ontario, at the conclusion of the 31st day of the trial of Chris Barber and Tamara Lich. Both are being charged with crimes related to their roles as organizers of the 2022 Freedom Convoy, a peaceful demonstration that was opposed to what I regularly characterize as the COVID-19 enterprise, a series of edicts, decrees, orders, mandates, lockdowns issued by governments, ostensibly in the pursuit of public health to reduce COVID-19 transmission. You all remember that. Now, the day's proceedings were primarily consumed by this ongoing dispute between the defense teams and the prosecution over this Carter application. Now, the Carter application is something that we had explained to us in our previous day's report, so please check those out to familiarize yourself with that process, that term, if you haven't yet done so. And we were fortunate enough to speak with Diane Magus, defense attorney for Chris Barber, and also Eric Granger, defense attorney for Tamara Lich, to talk to them about some of the day's proceedings. Also, we spoke with Adam from the Democracy Fund, who shared some legal insights with us. Before we get to that, though, please remember that we need your financial support to produce these in-the-field reports. So please visit tamaratrial.com, help us out, and stay up to date with our ongoing coverage. Prosecutor Tim Radcliffe today presented his arguments in defense of the Carter application submitted by the Crown, which the defense teams are seeking to have squashed without even a review from the judge. So in order to defend his submission, Tim Radcliffe characterized the Freedom Convoy as an unlawful protest. That's a quote. And he used other language that we've heard before. He described it as an occupation. He described it as a blockade. He described it as an unlawful assembly. And if he's able to persuade the judge that the demonstration itself was broadly or wholly illegal, then he can attach the two defendants, Tamara Lich and Chris Barber, as organizers of this protest, as co-conspirators advancing this criminal act. In other words, if the judge is persuaded that the Freedom Convoy itself was an unlawful act, then the two defendants are responsible for advancing it, for furthering it, and for executing it. And therefore, the Carter application, which seeks to apply a conspiratorial framework to this trial and allow incriminating evidence against one co-defendant to be applied to the other, would have a greater chance of succeeding to the point of being reviewed by the judge for potential acceptance. Tim Radcliffe characterized the mirroring of language between Tamara Lich and Chris Barber and the demonstrators in the Freedom Convoy protest as indicative of a degree of control and influence wielded by the two co-defendants over the protesters. Specifically, he was saying that since the same language shared by the two co-defendants in their public and private statements, such as freedom, such as hold the line, was seen on signage and said by demonstrators here in the streets of Ottawa, that again, the co-defendants had a degree of control. One line also was shared that love overcomes fear, or something along those lines. Love over fear. And Justice Heather Perkins McVeigh, the judge presiding over this trial, she interjected at that point and said, those are common refrains from politicians. And what was noteworthy there was that the judge was acknowledging that these sorts of messages, these values, these ideas communicated via language regarding freedom and liberty and ending lockdowns and mandates do not require some sort of top-down direction in order to arrive at. In other words, millions of Canadians can come to that conclusion on their own without being given some sort of specific directive from the two co-defendants. Guys, see you later.
Have a good night.
Bye. Obviously, the prosecution was making its argument for the acceptance of the Carter application today. They're trying to push back against your motion to dismiss the Carter application. Let's say the judge is to deny the defense team's requests to dismiss the Carter application out of hand. What does the next level of this dispute over the Carter application look like procedurally?
Well, the next level procedurally is if it gets past this stage, as the law from the Supreme Court is quite clear that a Carter application on the merits gets decided at the very end of the case. So if we're not successful on this motion, we get back again to argue at the very end of the case that the Crown hasn't actually proved beyond a reasonable doubt that there was a conspiracy here. They haven't actually proved that Ms. Leach was a part of any conspiracy. And the judge will have to decide it at that point, where if there's any doubt that there was an unlawful conspiracy at that stage, then she can't use any of those statements.
Now, your colleague Lawrence Greenspan remarked towards the end of the day that there had been several versions. Was he referring to the Carter application itself? And if so, does this relate to something I asked you yesterday regarding the Crown sort of buying itself more time to continually refine or revise its Carter application as events unfold, assuming that, as you just put it, Carter applications are normally decided or argued over at the end of the trial?
Not so much changes to the application itself, but changes to the argument. So it's they're as often happens in any kind of a case, as the case evolves and as you hear more from what the other side is saying, sometimes you realize what the other side is saying is right, and you abandon things that you were previously trying to advance.
And now one last question. I hope this isn't putting you to speak on Magus's behalf, but she made a remark at the end, or a question she had for prosecutor Tim Radcliffe about how many others were involved in the conspiracy, if I understood that correctly. And his answer was, many others are involved. Did I catch that? And if I did, how's that relevant?
So I caught the same as you, that he had indicated many others. It would be more relevant if they were alleging that there were others involved and were saying we want to use their statements as well against Leach or Leach and Barber. Then it would be more important for us to know how many, who they are, and what did they say that you want to use. But I guess we'll see tomorrow where Ms. Magus might be going with that.
See you guys. Okay, so Dan, at the end of today's proceedings, if I understood this correctly, you were asking whether other co-conspirators were going to be alleged to have partook in this conspiracy from prosecutor Tim Radcliffe. And at the end of the trial, his response to you was, many others will be included. Did I understand that correctly? And if I did, how is that relevant? How does that change future proceedings?
Oh, it doesn't change anything in other proceedings. It's just that in a conspiracy, there could be a small conspiracy, like with two individuals, or it could be a larger conspiracy with unindicted co-conspirators, for example. So you don't have to name people, but I just wanted to know if there was an allegation that there were more people to this alleged agreement than just the two, so that we can respond appropriately.
And now one more, we asked you before, maybe you can elaborate a little bit on this. Again, let's say the judge decides to reject the defense team's request to dismiss this Carter application out of hand and accepts to consider it at the end of the trial. What does that court process look like? Is it going to be another back and forth between defense teams and the prosecution over the legitimacy of the Carter application itself?
It would be an argument on the final test of the Carter, which is a test that's at this juncture, the test is more difficult for the defense. At the final juncture, the Crown would have to prove the unlawful common purpose and the agreement for that beyond a reasonable doubt. At this juncture, it's a much lower test. So it'd be the same argument, but with a different test applied.
A higher standard put on the prosecution to, again, beyond a reasonable doubt, those three rungs, right?
Yes.
Gotcha.
Well, no, for the first step. Gotcha. The other step is on the balance of probability, and the third step is whether each of the statements are in furtherance of that common unlawful agreement. But I would suspect if we do that, we're not going to be as elaborate as we were now, because we're not going to be exactly all the same that has already been argued, right? Like, we're going to summarize and point back our honor to it.
Okay, so I'm here with Adam from the Democracy Fund. Adam, against the backdrop of this entire Carter application dispute, We know that Tamara Leach's name has come up infrequently. She's been rarely mentioned across the evidence presented by the prosecution in terms of the witnesses and in terms of the videos that were displayed from the Freedom Convoy itself. So why is the Carter application so important for the prosecution in terms of pursuit of convictions of the charges against Leach?
Well, it's important for the reasons you just mentioned. I mean, since I've been here, which is mid-September, her name has only been mentioned a couple of times. It wasn't until day 27 that they started sort of looping her into their submissions. It's very important that they now start talking about her statements and her affiliations with Mr. Barber, because this is the basis for the Carter application. And without this, they're not going to have as strong a case against her because they won't be able to attribute Barber's statements to Tamara Leach.
The Crown is alleging that this conspiratorial agreement between Tamara Leach and Chris Barber took place over the course of a month. Why is that noteworthy?
Well, because, okay, let's think of it this way. In the relevant jurisprudence you've got for Carter applications, you've got murders and drug deals. There's an agreement made, for example, hey, let's get together and let's kill this individual, or let's get together and let's sell these drugs. There is a specific date, that they would have made that agreement. In this context, the Crown is saying that date is, 3 weeks. So it's sort of not specified in a clear way. Now, granted, they will be continuing their submissions tomorrow to some extent. I don't know whether it seems to be concluding remarks though, so I don't know if they're going to clarify that or not. But just from just simply thinking about this simply. An agreement is something that happens at a specific time, on a specific date. You agreed on this date. If you're saying that this agreement took place over the course of 3 weeks, that's confusing.
So just to make sure that I understand this, I want to be the sort of representative for the Rebel News audience out there, the laypersons. The Carter application is used usually, or maybe even exclusively, to rope in conspirators in the context of drug trafficking or murder or something like that. And that would mean that this sort of attempt to apply the Carter application to this supposedly allegedly unlawful protest is a novel application or an unusual application. And that secondarily, it's also unusual or potentially novel in that it's not they made this agreement at this time, at this place. It's like they agreed to it over the course of this 3-week time frame.
That's right. I wouldn't say that it's novel. I don't think it would be novel. But I would take your point in that it is strange that the agreement took place over a long period of time. It sort of muddies the water. It makes it very difficult to discern. Okay, when over the course of those 3 weeks, every day they agreed each day, or you sort of, and then this is where the waters are sort of further muddied. Is that you have police officers instructing people to come in and you park here, you park there. You have the testimony of Officer Bache, who noted that Mr. Barber was perfectly, well, not perfectly, but a lot of the time, largely compliant. And they both crafted a plan to move trucks out of residential areas. So are they part of that agreement? Is the police? There was also the letter of the mayor's office on February 12th, 2022, which is also sort of another agreement. Is this part of that agreement? When exactly did this unlawful plan come to fruition, and when was it exactly agreed upon? 3 weeks, from in my eyes, and I think as well from the defense perspective, is not a clear delineation of when that agreement took place.
Dear Rebel News audience, remember that we can't do this in the field reporting for free. We depend on your financial support to continue. And remember that we're not beholden to the federal government. We're crowdsourced. So help us out. Visit tamaratrial.com, contribute, and stay up to date with our reports.